Okay. Call the Morrow County Land Use Hearing. In discussion. And, our item of business today is the land use hearing, zoning ordinance update, data centers, site plan review procedures, accessory dwelling units, commercial trucks, temporary RV users, retirement standard for power generating facilities. And, before we start, I'm gonna read the, opening statement for land use hearings. Good afternoon, my name is David Sykes, Chair of the Multnomah County Board of Commissioners. I will be presiding over this legislative land use hearing. Persons who wish to provide testimony may do so orally or in writing. Testimony and evidence must be directed towards the criteria described in the staff report and findings for land use regulation believed applicable. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes an appeal to the Board of Commissioners on that issue. Please speak only when identified by the chair. Please begin your testimony by giving your name and address. If you have exhibits for our consideration, please provide a copy to planning staff. For persons participating via Zoom, please raise your hand or place a note in the chat so we know that you would like to speak. If you would like to request the commission to hold open the record or continue the hearing, you must make that request before the public portion of the hearing is closed. If the commission holds open the record, you may submit additional written testimony. That concludes the introduction, and now we will open the public hearing on AZ.143-23 zoning ordinance amendment, Morrow County applicant. And with that, I'll turn it over and we'll have the staff report from Tamara take it from here.
Thank you. For the record, Tamara Mabbitt, Planning Director, and I have with me today Daisy Goble, Principal Planner, and Landon Jones, Planning Tech. We've been tag teaming this effort since.
Sorry, can I do one more thing first before I miss something? I want to call for absence or conflict of interest. Is there anyone who has a conflict of interest on this subject? I'd like to declare that.
So the only thing, I guess, with the data center, but when I read through the packet, we aren't really gonna be doing anything on that today.
That's
Is that correct?
staff's recommendation, that's correct.
So I don't think I need to declare anything if we're going to be doing it.
Okay, yep, that makes sense to me.
Okay, hearing no conflicts of interest, so go back. Sorry, Tamara.
Oh.
Want
No,
to get
thank
that
you, though,
first
Dave.
before, okay,
Perfect, yep.
so we'll go back and Tamara will give us that.
You bet. So just introduce myself and the other staff. You have a memo in front of you. I already saw a correction there. It indicates there are two separate ordinances that are not. There's one ordinance for your adoption. Since your initial hearing on this on January 17th, which you continued to today, March 20th, we've had multiple meetings internally and then also with the Port of Morrow and their land use council and with Amazon Web Services and their land use council. And we see they are on Zoom today. And I understand David Almanero would like to provide some public comments. What we have in front of you today is a single ordinance that includes multiple code updates. These felt initially way back last fall when we had our first work session with the planning commission that most of these were housekeeping and streamlining, and this has been a protracted process. I think the end product will be is a good one, and as noted in the memo, we're recommending that you not adopt any changes to our site plan review procedures or the data center procedures, which fall under the site plan review category, and allow us to take that back to planning commission and vet it again more fully to make sure we understood their intent and to make sure we got all of the details. So once we started looking, once you make a change in an ordinance, it has reverberations, right? And other parts, we want to make sure we got that right. That's the piece about the data center. Do you want to say anything else about data centers, Daisy, or site plan review?
No, I think you really covered it. I think the big impetus there too is that it came to our attention that it's not necessarily data center specific, that the goals that we're trying to achieve for consistency, clarity, meeting the thresholds of clear and objective and administrative review and where those fall. And so just wanting to broaden it and look at our the different chapters with regards to how we process all different types of land use permits. And in doing so, we want to make sure we just have a really clear understanding of the planning commission's intent and make sure that it's consistent throughout the code.
Yeah, good. Landon has a couple of notes that he wants to add. He went very clearly detail by detail in January, but a couple of changes since that time.
Yeah, so after the January meeting, we kind of all decided that ADUs were gonna be held off for a while, so all of that ADU language was removed from the proposed code, other than the definition for an accessory dwelling unit on page 15 of the packet that you'll see. I think.
And then the trucking and then I'll say a few things about the ADU. I'll jump to the third page of the memo. Landon just mentioned accessory dwelling units. And as thorough as we thought we were about that, I think the way we presented it may have been misunderstood. So we had a lengthy, robust discussion about ADUs at the planning commission level, and we had several entities opposed to it. And I think there was this perception that it was optional whether or not we allow them in a critical groundwater area or a groundwater management area, and we do not. So the legislation, SB 644, provided counties the option of permitting ADUs in rural residential exception areas with some restrictions, and that included the groundwater management area and the critical groundwater area. So that should have been probably more clearly a staff recommendation. It got lost in the weeds with lots and lots of different people commenting. That item is also tabled, that the recommendation from the planning commission was to table that, so that's not in your packet to adopt today.
And then the other thing that we caught was the solar siting standards that increase the acreage that the county could permit without the state taking hold of that. What we changed in the code related to goal exception acreages, and the legislative update doesn't change any of those goal exception acreages, just what the county can permit. So those were all reverted back to their original acreage numbers in the farm zone.
Which is 12 acres of high value or 20 acres of arable lands. Anything larger than that requires the goal 3 exception. You're all gonna be goal 3 experts in the next year or so.
Yeah, and then do we wanna talk about trust? That's alternative.
I think once we do that and cover Marguerite's letter, that's kind of the wrap on the staff report part. I think so.
Yeah, so we did get a public comment about asking for this code update in the rural residential zones where we're allowing a single commercial truck or tractor unit now to also allow a single trailer with it. And we also have some draft language if that were the case. So if you were to look at page 36, for example.
In your packet.
Yes.
Oh. Yeah.
Yeah, so you'll have number 2 and 2A, and we made a draft addition as 2B, which says a landowner may be allowed 1 trailer attached to a truck or tractor unit. A trailer shall not be allowed without the attached truck or tractor unit. That's something we're not too certain on. Not sure if it solves the issue of those commercial operations in a residential zone.
I have a question. So let's just say this truck was hauling human waste
Well,
or Or solid waste.
Sure.
Or animals.
Oh,
Yeah, I mean, that probably wouldn't be something the neighbor would be appreciative of it sitting there. Just my thought.
Thank you.
it's important.
And yeah, the addition of the code to allow the commercial truck or tractor unit was specifically for if it's your personal transport vehicle, because some people use that as their personal transport to get to their work, to truck if that is their job, or maybe they just want to drive a big rig. So that was some draft language that we had prepared in response to the public comment.
And even in addition to that public comment, we have been working with some of the residential neighborhoods in the county. Those folks who run commercial trucking businesses want to stay in the residential zone and they have never been allowed in the residential zone. We're just trying to be consistent with code enforcement when we enforce that, and that was the neighborhood by neighborhood approach. Some of those folks, with those commercial trucking operations have moved. And are no longer operating those businesses in the residential zone. We heard from a couple that said, what harm is it if it's my truck unit and a single trailer? So we, Landon came up with some language, if you're inclined to allow the trailer piece. If not, it can stay as it is in the adopting ordinance as the truck piece only, not the trailer.
So the trailer part is not in there at this time, is what I'm saying.
Correct.
Okay.
Other changes, so Article 6, the conditional uses, all of the accessory dwelling unit language was removed from that as well. I think Article 4,
So, I guess, so to go back, maybe some history, Junior, on the truck thing, is that how this came about, because before, there wasn't anything against it, but and then the requirement came in, and they allowed the truck so that, like they said, you know, you're an over-the-road trucker, say you drive for Swift or somebody, you drive a company truck, you could drop your trailer like up here at Bakes and drive the tractor, the power unit home, spend the night and go back. You know, is to keep, you know, somebody from running a trucking operation out in rural residential, and how that came about, that, you know, before there wasn't anything against it. How it came about is because you had somebody here in Oregon that, was running a trucking company out of their residential, and they'd run the reefer overnight.
Oh, well, and that's another good point. Yeah.
And the neighbors didn't like the reefer running all night. And so that's when it came in that you could drive the tractor home, but you can drive the trailer home.
And we added that language because that had been a pretty common staff interpretation. That's why we're codifying it here. Tractor unit and a single one, if that's your mode of transportation. And if you're inclined to add the trailer piece, Landon has some language you can consider in your adoption. If you're not, if you were to approve this as a package, it does not include the trailer.
Okay, that's the.
Yeah.
all the changes in Article 4 relative to the site plan review, for data centers, that was pulled out. So the only changes that we have in there in Article 4 now are some continuity changes, for manufactured dwellings with the tax regulations for the county. And then you will also find that there are not the port industrial, airport light industrial, and general industrial zones in here, because all of those changes were relative to data centers, so all of that has been removed from this proposed language. I think that's all the difference from the last time you guys have seen it. If there's anything you want me to go over or address, I can do that.
Does that include the staff report?
Yes, it does. Thank you.
So I do have questions about, you know, the, retirement standards for power generating facilities, you know. What's the enforcement mechanism?
That's a very good question. If it's a locally permitted facility, we can require something like a bond. We left it pretty open-ended rather than being really prescriptive about it.
Because I read it and I forget what it said, but basically we have these requirements that you have to do this. somebody walks away from this, the development, they fold up the company. How do you enforce it? And, you know, back from, you know, when we first started requiring a bond for wind towers, you know, just $4,000 bond per tower, because they thought that would be enough, and I contend that that's not
That's not
enough.
enough.
You know,
Yeah.
but, you know, even with a bond's only good as long as you pay for it.
Mhm.
So you let your bond lapse. I mean, I fold up the, project. I don't pay the bond the next year. What do you do? I mean, cause you just, the company just folded up the company and there's no assets, so. What, so, you know, so when I was on the planning commission, bring this up, you know, there would be some of the landowners that were having these wind projects on there. Oh, we got the assurances from the developers and, you know, we don't think we need anything, we're comfortable with it, and it's like. Okay, then don't come to the county asking for the county to come up with money to take down these facilities when somebody walks away from them.
Mhm.
And so that's the same thing with the solar. And the solar would be a lot easier to get rid of the facilities than a wind turbine.
Yeah, for sure.
It's certainly much cheaper. to do,
A good front end loader and a chain,
Yeah.
and start ripping out posts.
Mhm.
Unless you're really good with the fallen trees for wind chime.
Well, like all code enforcement, it is a challenge. So this requires really a decommissioning plan.
Joe's solar developer walks away from the facility, and Joe's solar developing company, files bankruptcy or ceases to exist.
This may be a legal question, but if we have a bond, does it give us the authority to put a lien on the property for, if a situation like that did come up?
Or you call the bond, I mean, you can, because the bond is in favor of the county.
I mean,
But if
for
they
my
don't.
dealer's license, I have to pay for my bond every year.
Mhm.
I don't pay for the bond.
You don't get a bond, and
Well,
you don't get your dealer's license.
yeah, but if I'm a developer and I don't pay the bond and I'm holding up the project anyway, what good's the bond requirement? It's only good as long as the company's in existence.
Yeah, so do you have an idea for an alternative?
And Dave and I were talking about this earlier, and I don't, you know? Because Dave, my conversation was, when you're in this position, you're supposed to not just point out the problems, you're supposed to come up with a solution.
Yeah.
Cause I don't know what the good solution is.
Well, you know, I remember they put a big wind farm in California. I can't remember now. It was a valley down there. And I drove through there and they had quit using it.
Mhm.
And the wind towers were falling apart and nobody had done anything. And I don't know. I just, in a deal like that, I would just want to know, what did somebody else do? I mean, we're very rarely the first one up the hill on these things, you know? I mean, there's wind farms were built all over the place. You know, I always like to steal other people's ideas. What do they do in Texas where they got more wind towers than 3 times of Oregon, you know? Are they must be doing something.
Yeah,
But that one in California, I know, that was one of the first ones, and they didn't do anything. And like you said, Jeff, I remember looking at, and there was blades laying on the ground, and not, a couple of them were turning, they weren't hooked up to the grid anymore. And it was just acre after acre through this once beautiful valley. It was full of decomposing wind. I mean, it was,
Fremont, that area, is that the one you're talking about? Fremont or Palm Springs?
could be, I was trying to remember when we got to talk, I was trying to remember what that was. I had read an article and I had drove through there, and then I thought, yeah, I hope that somebody learned a lesson off this deal.
So, I guess, you know, something I think I brought up before, you know, at the planning commission, and, you know, just, it came back to me is that the idea of posting a reclamation fund, kind of like within the Buttes, where there's that fund that's out there
Mhm.
that, you know, sits in perpetuity, so that whenever it closes, here's a fund that's active. They don't reclaim it to the standards, you know, so would that be a possibility, is that the developer has to,
Sure.
you know, instead of maybe funding it all up front, that they have to do it over
What if,
so much over the expected life of the facility, Because, you know, that's what they'll say is that it'll be a huge financial burden to them,
Mhm,
but if they're funding it over the life of the facility,
mhm.
and then there's that money in escrow, and then if they do what they're supposed to,
You get the money back.
exactly.
Uh-huh.
NextEra is one of the biggest renewables in the world. I mean, would they show you what some of their agreements are other places, you know? I mean, or what if you asked them?
Mhm.
What do they call, what are they required to do? You know, to, I don't know, where are they big at? They're big in the south somewhere. They're down in.
Next there, I think their headquarters is Florida.
Yeah, Florida. I don't know if that's where they put the wind towers.
So we could sure research financial assurances other than for a bond. Do I hear you say that you are in favor of a retirement standard, but to come back with some
If you
better
have-
ideas other than something like a bond? And we didn't reference a bond in.
No, but you can have the standards, but if you have no way to enforce it, it's not just the paper it's written. I mean, you can have all the rules, and if you don't enforce the rules, what's the sense of having the rules?
Yeah.
And if you have no mechanism to enforce them, they're even more worthless.
My understanding is that EPSEC has a bond requirement, because we get a copy of that bond. The bond renewal for some of those, but the point is, a bond is only as good as. it's paid in
Yeah,
kind.
didn't you have those bonds, they're like life, you pay a large sum up front, and the bond lasts for a certain number of years? I thought I heard of those before. Like a 20-year deal.
I don't know.
I thought I'd heard of those before. Swear.
No,
You do,
My
it's not
experience-
year to year. It's
My-
not like like a bond you take out for, somebody handles funds or something, you know.
Or a contractor has a bond.
Yeah, contractors bonded, they say unlicensed is bonded, but they pay that every year, but
Yeah.
I thought I've heard of bonds where you take it out over the life of a certain number of years and you pay all the money up front for that bond. And basically the bondholder's taking the risk. And they research it, and they decide, well, how much am I gonna charge them for $100,000 bond? Well, am I charging, you know, for 20 years, you know, am I charging 10 grand, whatever. They're fiduciary people or numbers, just figure that out, you know, but I thought I heard of those people.
I don't know that,
Oh, okay.
but if there is such a thing, then that covers, you know, my concerns of
Mhm.
a bond.
So again, the language in here is, we borrowed this from some other documents, but it didn't specifically have the bond requirement. If you want, you could go ahead and adopt this, and then we can look at other options for implementing it for that financial assurance piece. It's always a gamble,
I don't have a problem with requirements, it's just.
Well, now you go back to, what's the acreage limit to where it gets kicked up to the state? Pretty low,
for solar, it's now 240 if it's high value, 1280 if it's arable, and
huh?
2000.
Like state. So anything above that, we're not gonna have any input on any bond or anything else, so.
Not if they're larger,
Yeah,
but the state does.
yeah, I know, but, you know, we talk about, well, what about a solar or wind farm, when they moved to, I don't know, when's the last wind farm we did, that small one down there in South County somewhere? The Orchard, didn't we do Orchard? That was the last one the county did, isn't it?
I think that's right. I wasn't here, but I think that's right.
Yeah,
And we have another wind project that's in front of EPSEC tomorrow.
in EPSEC, that's the
EPSEC,
state,
mhm.
not the
And
county.
they-
I'm talking about the county, because we have no control over if they pay a bond or not.
If it's at EPSEC.
Well, if the state thing, yeah, if it goes to the state,
Mhm.
well, most of the projects now are big enough, we're not even doing them.
Yeah, I think we'll probably see more of the smaller ones.
Okay, I
have-
mean, I'm not against being prepared, I'm just saying, I mean, you know, does Wheat Ridge, if they walk away from, they go bankrupt and walk away, is there any protection on their towers sitting out there falling apart? Because we didn't have anything to do with Wheat Ridge.
Well, I'd have to look at the site certificate, but they build in things and they rely on a bond, but maybe others. And so, I mean, it's definitely a good idea to research it.
Yeah, but it's up to the state, not Gilmore County.
Understood.
Yeah, so, I mean, but this takes care of the ones that we would handle.
So would FSAC look at if we had a different requirement than they do for financial assurance? Would they look at our requirements since it's in our county?
Well,
They
if
look, they look at our land use stuff or are supposed to.
supposed to, yeah. I think generally they do unless they don't like it, and then they ignore it, which is why we had filed a friendly brief. Dan Kearns, do you have any thoughts about how we get financial assurance for a retirement for a renewable energy facility other than through a bond requirement?
Hi, can you hear me all right?
Yes.
Okay. Generally the bond is the best way because it'll be sitting there for a long, long time. As a government attorney, I'd much prefer kind of liquid assets like a letter of credit or cash, but most operators don't want to tie up actual cash for such a long period of time. In my experience, it comes into play for cell towers because there's always this thought that, once they're approved, they are only going to be there for a couple decades, but they're there for a long time. And so bond is the only feasible mechanism for paying for the, dismantling and removal.
Well, no, okay, as long as you're talking about that, are there long-term bonds that you pay with one lump sum, or are they a yearly thing like Jeff was talking about?
I don't know. That's a kind of a surety company question. I assume that the long-term is available, that you don't want this thing to expire because they didn't make their annual payment. So it'd be something they would have to usually they have to pay a certain percentage of the face value of the bond in order to get the bond. They pay that and the bond is in place for X years. So if you want this thing to be in effect for 20 years, that's what they would have to get. And it wouldn't be dependent on an annual payment to the bond company, because guess what? They're not going to do that. You'll wake up one morning and say, hey, they didn't renew it 5 years ago.
That's how actually most franchise agreements are written. So it's approved for a 10-year period and it's renewed every year. So it's a continuous rolling 10-year period. I guess we could ask for upfront or something.
Yeah. And is this mostly concern for wind projects or solar or both or what?
Oh,
Is there, I can't remember these agreements. I remember we looked at them when I was on planning. Did they have a built-in lifespan where they say they're gonna go this long and then they're gonna be dismantled and removed, or do the agreements all just say?
They usually estimate, but they almost.
Yeah, but they don't set a date, like, if they say, okay, we're gonna have these dismantled and removed by this number of years since after approval. Because you wouldn't know how long to set the bond anyway. I mean, if they're not planning for deconstruction,
Mhm.
they don't know how long they're gonna last, they're not planning for deconstruction, then you can't really put in a penalty or bond thing anyway. Cause see what I'm saying? Unless you
These
take
things are forever.
well, they have an expected,
forever, oh, okay, that makes sense. I like
They have an expected life.
forever.
they have an expected life expectancy.
Yeah.
Of,
But it doesn't matter,
Yeah.
so if you have a forever bond,
Yeah.
then it doesn't matter.
Well, like the solar project we heard from today, if that.
40 years.
40 years, yeah,
Yeah, well, they can run as long as they want if you have a forever bond.
but they'll probably upgrade the panels. In 10
Yeah,
years.
they'll always want something there. They'll replace it and upgrade it, but there will be something there.
That's a business decision we don't have to worry about. All we're worried about is what are they gonna do with it if they abandon it.
So I don't know that we'll resolve it today, but we can continue looking at creative ways to get the financial assurance. And those are for the projects moving forward. And
Yes.
really, all those that we have now that are county approved, we're kind of at the mercy. And even I'm aware of landowners, maybe not even in this county, who have lease agreements and they really have no say over the dismantling and retirement. It wasn't something negotiated in their lease, and so it's not something they can argue about. So it would, without any really clear financial assurance, it would be something we'd have to pursue through code enforcement, I would presume. Could be slow moving down.
Yeah.
Well, again, if the developer's not in existence, then your code enforcement's against the landowner.
Yeah.
It is, yeah, it is.
Okay. Any other questions for, because we got one hearing about this, handle two subjects here, so we've got a question to answer on both subjects. Okay, and I'm gonna open it up for testimony. Is there anyone? Say in the room, that made me look stupid, but I'm gonna say it anyway for the record. Is there anyone in the room or on Zoom that would like to testify in favor of this?
Got a hand up.
Yes, David.
Hey.
Just state your name
Hi, thank you.
and,
My name
who
is
you're-
David Amanero.
okay,
My name is David Amanero. I'm at 221 Newell Street in Walla Walla. Actually, today I happen to be in Texas for work. But I thought you were calling for in favor of is this the issue, the first issue of like remanding or section or Article 4, the data center issue procedures?
we're combining them both. It's one hearing, so whichever one you want to, if you want to speak to the data center, go ahead.
Yes, please. Thank you. And so this is really important to me, and I apologize I can't be there in person. Like I said, I live in Walla Walla, but work has me in Austin, Texas today. But I think the weather's nicer over where you guys are, so I'm bummed to be over here. I do want to echo a lot of the things that Tamara said. First of all, thank you to the planning department for the collaboration up to this point. We met with the planning staff at least 5 times since January 17th. And so we are very appreciative of their time and their collaboration. We do intend to continue collaborating with the planning staff to bring a sort of consensus draft of the Section 4 or Article 4 changes to the Planning Commission for their consideration and for their future recommendation to you on the Board of Commission. And so I guess I'd like to just part with saying, we in the meantime, until we're in this area where we see some deficiencies or the planning staff sees some deficiencies in the code, and until we get a new ordinance approved in this county, that we just remain committed to working with the planning staff on our in-flight, our upcoming developments, and we do look forward to that application process that's going to apply to equally, like I think it was Daisy who said, kind of equally to old data center or old developments in the county, not just data centers. So that's it. Thank you.
Okay, thank you. Is there anybody else that wants to speak in favor of this? Is there anyone here that wants to speak in opposition?
Who's Galaxy Note?
Just came on.
What's up?
The Galaxy Note 10 just came on.
If you would, we have this muted just to keep from Zoom bombing, so just raise your hand if you would like to make a
Raise your
comment.
hand if you want to make a comment. You can speak. We're at, for those in opposition, but if you're in favor, since you just got here, you can go ahead. Did you want to comment? Like I said, or else you raise your hand if you want it. So we don't see a hand, so, okay. I guess I forgot to call too. Is there anyone who just wants to make a comment? We have that category too. Not in favor, not against, just make a comment. Okay. Okay, with that, we'll close the public hearing portion of the public testimony portion of the hearing. And the commission will deliberate, and make a decision. Okay,
Did you close public testimony or close the hearing or
no,
both?
I closed the public testimony.
Okay.
I corrected myself,
Okay.
I think. I'm pretty
You
sure,
did,
that's what I
you did.
wanted. I'm just gonna close the public testimony of the hearing. I think I incorrectly said it the first time, but
So, Chair, draft ordinance is on page 11 and 12 of your packet. Today would be the first reading. The second reading would be on April 3rd.
Okay. If we approve it,
If you approve it, yes, that's right.
okay.
Sure, if I might, if it's a, if I
Yeah.
might, I just, say thank you to David and to Steve Pfeiffer. We've been at it, for a while. I think our last meeting was the day before we needed to post the packet for the record, and we just weren't exactly aligned. But it's been, a positive and fruitful discussion, discussing difficult topics, and in my career as a county planner, I've never really dealt with an urban scale development outside of a city limit or urban growth area. So it's really a whole new approach to things, which is why we recognized our code needed some little fine tuning to address those things. And the Port of Morrow has been actively involved as well, and that's been very, very fruitful as well. So next time we have a light planning commission agenda, we're gonna work session with this topic with them. So,
For any future projects out in the county at large, right?
that's exactly right.
Okay. Any other, think anybody else wants to add here? Okay, what's your thoughts, you guys?
So just for clarification, so I read the ordinance here quickly.
Mhm.
So it would be, we're sending back the data center site plan review for the planning commission to look at again.
Mhm.
But we'd be reviewing the changes that address the accessory dwelling units, commercial trucks, temporary RV users, and retirement standards. So adopting those red lines that were in the packet.
Right, and the ADU is the definition only, just so we have that in our code, right?
Just,
I just wanted to make sure I
You got it.
understood exactly what we were doing.
Yep. You got it.
So I approve for.
You need to close the public hearing first.
yeah, no, I'd close the public testimony. I don't
But
want to
it's still
close the
part of the
hearing
hearing
until
while we
we're
make-
done.
To make a decision.
We make a decision, then I close the public hearing. But I close the public testimony.
Dan? So they, can you help us on the procedural thing?
Sure. It's kind of a distinction without a real difference. The public testimony portion has concluded. Technically, it's still a public hearing because the commission is going to be deliberating and deciding. It's just that people can't testify from this point forward. So I've seen it go different ways, but it's been pretty clear that the chair went ahead and ended public testimony after everyone had a chance to say their piece. Now the board deliberates and decides, and when the item is over, then the whole public hearing is over as well. You could view it that way, and that would be fine.
Thank you. My experience is we close the public hearing, but you don't adjourn the meeting. You're still in the meeting, so.
That works too.
Oh,
Yeah,
I was trying to remember back on planning. I thought this is the way we did it, is you close the public testimony, then you finish up, vote, and close the whole hearing. But I replicate. Because you might have 2 or 3 different hearings.
And particularly since this meeting is a standalone hearing, we wouldn't even close it because then the meeting would be over.
But according to the legal, it doesn't matter, right?
our code says hearing,
Yeah.
but it's okay.
Yeah, you've been very clear about what you're doing and people's participation rights when they're on, when they're off.
It
So
only matters when you get appealed.
right, just don't mess up.
Yeah, then you watch it go to the Supreme Court. Okay, on procedural problems.
So I'll move for approval of ordinance number ORD 2024-03.
All second.
Moved and second, any further discussion?
So in that discussion, do we have to read this in full, or how does that, when does that get read?
Just.
Or is it because it's posted?
As long as it's posted.
I know in the past, we used to have to read it literally verbatim and
Yes.
it's very.
Yeah, as long as it's been posted, well in advance, it's okay.
Okay.
I think you're entitled to do first reading by title only. You do a 2 reading system here?
We do.
Mhm.
Yes.
Okay, then usually it's first reading by title only.
So we do need to read an ordinance amending the Monroe County zoning ordinance then.
Already.
And the ordinance number.
Okay.
Got that, Valerie?
Yes.
But
I just want to be sure we were doing it right.
And can I ask a procedural thing since it's a little bit different? Dan, do you recommend they sign the findings then, at the second reading of the ordinance? So they're
Yeah.
the same. Okay, thanks.
Yeah.
We'll recommend adopting the findings, in 2 weeks.
okay, before we vote, any more questions on legal or anybody else? Make sure we got, no, we want
No, we went
to,
right.
in order, right?
Yeah, you did it
Yeah, I'm a veteran of loves.
right.
Okay, that's not on the record. Okay. Been moved and seconded. Any further, just, okay, all in favor?
Aye.
Aye.
All opposed, okay, motion carried.
Thank you. Okay,
Okay.
less than an hour. Perfect, thank you.
Very quick question, was there a reason that you brought, that you lumped these two together? Was it? It's all one thing, is it? I mean, the two.
It is, and again, as I said initially, they really felt like housekeeping. And
Okay.
then each of these most of these changes became much more nuanced and complicated. And that's why, after January, we were going to set apart an ordinance and your findings in a packet for the Article 4 and the data center standards. But we just pulled those entirely. So that you could have that discussion and maybe approve one and not the other.
The whole site plan review updates will be a whole different ordinance number, a whole different process, a whole different posting.
Okay, they just seem so different to have people testifying, but that's okay. That's fine.
Yeah.
Curious how how that went down. So.
Maybe we were too ambitious to do that much work in a short period of time, but when we started, it just seemed fairly straightforward. So thank you for that.
I just curious. I'm curious, that's all, Tamara. I'm not trying to
Curiosity is
micromanage the
good.
Planning department.
No, it's good, and I'm gonna double,
I'm nosy, okay.
no, that's,
All right,
your job.
anything else? And I'll call this hearing adjourned. Okay?
Okay, thank you.
thank you.